Greetings, Derek DeBrosse, gun lawyer here, coming to you from Columbus, Ohio. Munitionsgroup.com, munitionsgroup.com. Anything you need regarding the firearms or weapons industry, we're here to help you guys. Please spread the word, link us, like us, do whatever you need to do. Drop comments below if you have any. We'll try to get to them when we can. Today's question states, is displaying a firearm to stop an imminent physical threat a legal option? It's absolutely a legal option. There's an ongoing debate in the legal world and the carry world, to be quite honest, as to whether or not brandishing or even announcing that you have a deadly weapon such as a firearm is in fact a use of deadly force. Standard is different on the use of deadly force versus non-deadly force. It's my belief that generally speaking, the mere act of pulling a firearm without shooting it can and oftentimes does constitute an act of deadly force. The reason for that is that if you're not justified in pulling a firearm, you pull it on somebody from a deadly force standpoint, you may have just committed a crime. We've defended people in this office before, or this office has defended people before that have pulled firearms on people. One instance in particular I can remember, the gentleman pulled a firearm on somebody. It actually wasn't loaded, which we had a long discussion about that as well, which is something I never recommend. But he did pull the firearm, didn't shoot it. Obviously, it wasn't loaded, but didn't attempt to shoot it. And he was charged. He was charged with a very serious felony. It was, I believe it was felonious assault. He was looking at 11 years in prison, 3 years of which was mandatory, because he pulled that gun. And it came down to whether or not he was justified in invoking deadly force. So the other way to think about it is it becomes a circular argument in a way, because if I pull a gun on somebody, I'm not justified in using deadly force. I've now created a situation where that person believes that I may harm them, and they may think their life's in danger. They may pull a gun on me and say they were now justified in utilizing deadly force because of my act. I do believe the mere act of pulling a gun in your mind should be considered deadly force. If you're going to pull the gun, you're going to use it, plain and simple. There's no other reason to pull that gun, in my opinion. You just escalate things that need to be escalated. But talk to your tacticians, your tactical trainers. They would have more insight in that than I would. But from a legal standpoint, you do find yourself in a precarious position. If you pull the gun, make sure you believe you're justified in using it, because once you get into that level of aggression or that level of defense, there's a very good chance that it will be used. Never pull a gun out of anger. Never pull a gun just to piss somebody off or to try and scare them away. That's not what it's there for. It's there as our last line of defense to stop a threat if we feel that we're justified in doing so. So keep those things in mind. I hope it answers your questions. I'm sure we'll have comments on this one. I'm sure we have different opinions. That's fine. If anybody has any case law or statutory citations that say differently than what I've said, please drop them in the comments below. We'd love to hear about them. As always, remember to be safe out there and carry on.